It's great to have you with us today. We're talking about tenant buyout agreements with a tremendous eviction attorney. And before we get into that, thank you for being members with AOA. I know many of you are members and want to welcome those of you that are entering the Zoom call right now. You can hop on the Zoom call with us and we answer questions there first. And just want to say that we are really dedicated to your real estate success. And one way that we do that is having seminars. We've had a bunch of seminars recently, and we have some more that are going to be coming up in October. And I want you to know about those. They're going to be in Fremont, Santa Clara, Sherman Oaks, and Buena Park. Those are coming up. And so those will be about avoiding procedural mistakes in eviction actions and essential security deposit information. And in addition to the in-person, of course, we have the online stuff. And recently we did the membership orientation. And so whether you're a new member or you've been around a while and you're maybe not utilizing everything and you're kind of wondering, how do I set up tenant screening, or where is that office that's close by me? And anyway, so watch the membership orientation. We had one about insurance. I know insurance is just a hot topic right now and really a sore point for many of us, being canceled or non-renewed and dealing with inspections and then the crazy stuff that comes back from that. 10 mistakes when filing an eviction notice, and 10 ways to keep your renters happy. Those are all just recent things that we've done online. And so if you missed any of those, maybe you should subscribe to this channel and not miss them. But also open your email, because we're sending out updates and just letting you know in advance about these different presentations that we have. And anyway, we're going to get into it today. Many of you are aware of know our speaker. He's done over 300,000 evictions, been in the business for over 45 years, 29 attorneys on his staff, and we're so thankful for him. He writes the legal Q&A in the AOA magazine, and he's the founder and the president of Dennis P. Block and Associates. So, hey, Dennis, it's great to have you on today.
And nice to be here. I always appreciate the opportunity to talk to you and your members. And again, everybody, the association, the Apartment Owners Association is such a valuable asset to income property owners. And if you're not a member, you should be a member. The cost is so nominal. And again, you get to hear these types of seminars and use their form. So I'm a big fan, Jeff.
Oh,
Uh,
thank
but
you. Appreciate
but
it.
before we get into our topic, which is basically cash for keys. And I don't mind actually just telling you something, Jeff, and that is, and I don't mind everybody else listening, I have an investment opportunity for you, Jeff.
Okay, what is it?
Okay, so this is what it is. You're going to give me $30,000 as an investment.
Okay.
Then the return on your investment will be $1,500 per month for the rest of your life. Now,
Okay.
assuming this was guaranteed, you're going to give me the $30,000 up front, but guaranteed you are going to get $1,500 for the rest of your life. Right now, Jeff Fowler, would you accept this offer?
That 30,000 sounds kind of painful, but I definitely have to take the offer.
Well, that's very smart of you. Now, let me tell everybody, I don't have that deal. Okay.
Oh, man.
If somebody would offer that deal to me, I would take that deal. So why am I talking about this? And that is, well, many of the members out there, income property owners, have that deal. And let's explain how that's possible. If you have a rental unit that is currently suffering under rent control, and the rent for that unit is $1,500, but you know that you could easily, after you did some renovation, get $3,000 per month, you'd be making an extra $1,500 per month. But of course, you're stuck under the insane policy of rent control, which of course is just a degradation of our free economy. But what if you walked over to that tenant and you offered that tenant $30,000 to move, and the tenant accepted your proposal? If that was the case, then in that situation, you just made the deal that I just offered to Jeff, because on that case, by giving $30,000, and that's just an illustration, you could offer any amount, but you know yourself, guaranteed, you're going to make an extra $1,500. I want to share my screen with you because I did up an illustration on this. And let's figure out where that is, right there. So as you can see here, this is a tenant buyout. And as you can see here, where the current rent is $1,500 and the market rent is $3,000, that means you're going to make an additional income of $1,500 per month. And if the relocation is $30,000, that means you break even after 20 months, not even 2 years. And then after that, you got to return on your investment. And then from that point forward, you're going to have a situation where you are now raising the value of your property. Your income is going to go up on a yearly basis. Also, if most buildings sell on some sort of a multiplication factor of approximately 17, by raising that rent, the yearly rental increase on that is astronomical in terms of the value to your building by just getting one tenant out and raising the rent $1,000 or $1,500 per month. So this is an effective strategy that will, if you're suffering under rent control, this is an incredibly effective strategy. Now, before you start offering tenants money, understand that municipalities encourage you to do a lawful eviction against your tenant. Now, that might sound strange. How is that possible? The municipalities, they're all against us. They don't want us to evict our tenants. But let's think about it. If you have a tenant who's not paying rent and you evict that tenant, guess what? Without relocation money, you get to raise the rent to market value. So before we start talking about buyout agreements, or as what we do in our office, we call them voluntary vacate agreements, you want to see if the tenant is violating their contract. I've had people saying, gee, I'm really suffering under rent control and I could get so much more for the unit. And I'll casually ask the client, well, does the tenant owe you money? And they go, oh yeah, he hasn't paid for the last 3 months. And I'm like dumbfounded, because in that case, you want to immediately serve a 3-day notice. If you do, and the eviction goes forward, you're going to be able to evict that tenant, and you're going to be able to raise the rent to market value. So you want to look for any violations of the rental agreement. Let's pretend you are a dog breeder. You love dogs. You show them in fairs, and it's your favorite animal. But if a tenant brings in a dog and the rental agreement says no dog, you want to jump on that. You want to serve a notice to perform or quit, giving him 3 days to get rid of the dog. And if he doesn't and you evict, now you have the right to raise the rent. The same thing is true for any alterations to the property. If a tenant alters the property premises, maybe he puts an air conditioner in the window, that's an alteration. Maybe he put in a washer and dryer. That's an alteration. These are the situations, even if you like the tenant and even if the alteration doesn't really bother you, these are things you want to seize on if you're interested in getting around rent control. However, if in fact, oh, let me stop sharing my screen. Sorry about that. If in fact there are no violations of the contract, okay, then in that case, you want to attempt to do a cash for keys or voluntary vacate. It doesn't hurt to ask. And again, we've seen the illustration. your value of your building will go up approximately $300,000 on a $1,500 increase per month. So it makes sense to offer money to move. I want to talk to you about a personal example that I did with family-owned property. And that property was on a street called Croft near Melrose. It's basically La Cienega Melrose, a very nice area. And the family owns a duplex, which we still do. It's an upstairs, downstairs duplex. In fact, many, many years ago, I lived in the upstairs. Anyway, the rent was ridiculously low for this duplex. And the top person was paying $1,200 per month. But this is many years ago. I would say about 10 years ago. The bottom was paying $995, way under market value. Well, it just so happens that the tenant upstairs decided to move. Of course, we were thrilled. And then I approached the bottom and I said, you know, if you look up and down this street on Croft, you're going to see that many condos are being built. And it's our intent to build condos. So we're going to be asking you to move. We're going to pay you the stated relocation, which at the time was about $20,000. And we're going to ask you to move because we're really planning on tearing this down. And this lot's big enough to have 6 condominiums. And as you can see, that's what's happening up and down the block. But I said, you know, I don't really think it's fair. You've been here for so long. You've been good tenants. I would like to do something more than that. I would like to give you $25,000, and instead of doing a 60-day notice to move, I'm going to give you a 90-day notice to move. Well, I negotiated with the tenant, and it turned out I actually paid him $37,000 to move from that unit, and we did give him 90 days. Now, the truth was, I really wasn't planning on building condominiums. I just really wanted them out, but that's what I said to him. And I had him sign a voluntary vacate agreement, which totally absolved all liability on the part of the landlord. And he did move. Now, those were the 2 units are now vacant. We spent a ton of money fixing them up. We actually put a brand new garage in the back. Every surface was changed from hardwood floors, new kitchens. We actually added in a second bathroom. So it was 2 bedrooms, 2 baths. We spent a lot of money. But you know what we're getting now? One was 1,200, remember? And the other one was 995. We're getting for each unit $5,500 per month for each unit on Croft. The return on our investment is astronomical. So this is a strategy of trying to get by rent control. When you try to get by rent control, either if you have a violation of the contract, even if that you don't mind, but you need to use that, you need to strategize that because the idea, and it's really your patriotic duty to get around rent control because that's against our free economy, against our capitalistic society when they institute rent control on only one industry in the entire United States. You think about that? Only one industry. Jewelry, you can sell it for whatever you want. Baby formula, you can sell it for whatever you want. Prescription drugs, only one industry that they come after. And that, of course, is income property owners. So it is always a good idea to approach the tenant, have a dialogue with the tenant, and see if you can come to a meeting of the minds. Now, there is no specific amount. I don't care what you've heard or what the story is. You can offer your tenant $1. If he accepts, we put it in writing, that's a firm contract. He might say he wants $100,000. That's also would be fine. It's whatever the two of you agree. If the two of you agree that you'll pay for his dinner and a ticket to Disneyland, that would be proper compensation. So again, there is no specific amount. Well, I read that somebody said 24,000. There is no specific amount. It's exactly what the two of you agree upon. So if you want to come with a story that says, hey, my mom wants to move in, even though she really doesn't. But if you can get them to sign a voluntary vacate agreement, and of course, that's what my firm does, and we put in all these admonishments so that nobody can come back to you, even though grandma doesn't move into the unit, okay? You're way ahead of the game. So this is an effective strategy. So let's share our screen again. We're going to now talk about what are the issues dealing with, what are the issues dealing with an agreement, okay? And by the way, I had this illustration done by ChatGPT. That program is insane. So, because God knows I can't be an illustrator, but it does look pretty good. So, in any event, these are the issues to consider. Number one, how much you're going to pay, and that's really determined on what is the amount you could get for the unit? If the amount you could get for the unit is an additional $200, that's not going to be worth much relocation. But if you can get $1,000 more, that's $12,000 more income per year. And if you're talking about a multiplication factor of 17, you do the math, 17 times 12 $1,000. That's what the value potentially of your building has raised just by getting rid of this person. Is that worth $20,000 to you? Is that worth $25,000? So that's what you have to do. You have to back into the equation. Of course, you have to have the money. But if you can get the tenant to sign this, you're going to, again, get this additional revenue every single month for the rest of your life, and you're exponentially increasing the value of your property. The next thing you want to consider is the vacate date. Well, when is he going to get out? Okay, oh yes, I'm going to give you $20,000, but if he wants to get out, in the year 2030, it's probably not going to be smart. So you got to negotiate not only the amount that he's going to get, but when. But you could be somewhat generous on that topic as long as he signs the agreement where he's going to get out in 6 months, 3 months, that's all can be negotiated. The next issue is when is the money going to be paid? You're going to pay it to him all up front? You're going to pay it to him half now and half when he vacates, or you're going to pay it to him once he vacates? These are the things that you have to consider when you're having this discussion with your tenant with regard to this buyout agreement. Again, if he's paying market rent, you don't care if he brings a dog in, potentially. But if his rent is way below, then you either want to get him on the dog as a violation of the contract, or you want to enter into a voluntary vacate. And there's nothing wrong with that. That's not harassment. You're giving the tenant an opportunity, just like I gave Jeff an opportunity when we started this. So when is the money going to be paid is an important. I think you should give him some money up front and then the rest at the back end once he hands you the keys the to the kingdom, so to speak. The next issue is what about the rent to be paid during that 6 month period that he's going to live there? That's something you need to negotiate. Maybe you want to say, in addition to the relocation, take 3 months, you don't have to pay me. That would be a good extra sweetening to the pot that will incentivize the tenant to vacate your unit. Also, you also want to talk about the security deposit. If you're going to do a renovation, which you probably are going to have to do, you know what? Give them back the entire security deposit because you're going to be renovating the unit only. So these are the issues that you need to talk to your tenants about once you get that. So you go through that checklist of amount that's required, when he's going to vacate, when the money is going to be paid, and is rent paid during this interim period that before he vacates, and finally the security deposit that maybe you're going to throw that in, maybe you're going to throw in the rent. But these are the important aspects that you have to negotiate with your tenant. And again, this is just a win for you. It's really not a win for the tenant because when the tenant goes out and tries to get another apartment, that $30,000 relocation is not going to look so sweet to him. Now, we have to be aware of certain jurisdictions and they have their rules. And one big one is the wonderful city of Los Angeles. So I want to go to that one. And Let's see if I can find it here. Bear with me. There it goes. I see it there. Let me share my screen again. The city of Los Angeles, what is it? This one here has a form that's called the Disclosure Notice, Tenants' Rights, Rent Stabilization Ordinance Buyout. You have to technically, before negotiating with the tenant, if your property is under RSO, you have to offer him this, you have to give him this statement to sign before you talk with him. And this just tells him all of his rights. For example, in the city of Los Angeles, there's a 30-day cooling off period where the tenant, after he accepts the deal, has 30 days to reject the deal. If he doesn't reject the deal, then the deal will go forward. So they have to have this. Now, this form is tremendously confusing, and I'll explain why in one moment here. If we look at this, and I'll make this a little bigger, they have, if you look at this first chart here, they have what they're kind of suggesting what the buyout should be. This only deals with no-fault evictions. It has nothing to do with a buyout agreement, yet they put it on their form. Again, you can do a buyout agreement for $1. You can do a buyout agreement for $100,000. So they totally confuse everyone by putting this chart, which has nothing to do with a buyout agreement. If you read right here, it says no fault evictions, owner family move-in, governmental orders, or demolition to the projects. It has nothing to do with a buyout. Again, there is no specific amount for a buyout. But technically speaking, in order to be legal, you got to say, hey, here's this form. Now I want to start talking to you in the city of Los Angeles. Now, let's talk about another important thing, okay? And actually, I'm going to ask you, Jeff. Let's put you on the spot here. Got to do that a little bit. So you have this tenant, Jeff, in the city of Los Angeles under RSO. You gave him the disclosure form. You negotiated him in fairness. You found yourself online a cash for keys agreement that spelled everything out and the specific date he's going to move. And in the way you negotiated this, Jeff, you gave him all the money up front. He took it. He cashed it. He went out and bought a new car with it. And then the day came, the vacate day came, and he doesn't move. What's your next move, Jeff?
I think I'm calling your office.
Well, you might call my office, but you know what I'm going to tell you, Jeff?
You're out of luck because you should have given him the money like that, right?
No, I'm going to tell you that even though he signed a statement in the city of Los Angeles with the disclosure, you paid him the money, you lived up to every single part. In the city of Los Angeles for RSO, there's 12 reasons to evict. 12. Guess which one is not there?
Right.
One is the one that's not there is I agreed to move, I took the money, and now I'm not moving. That's not a ground to evict. So the only thing a landlord can do with that cash for keys agreement is to sue for it. So you got to go to small claims court. Can you get the tenant to move? Absolutely not, because it's not a ground to evict. And that's why I came up with another idea, which we have used this agreement. We call it a voluntary vacate agreement. And if you use my agreement, we have the best chance of actually evicting the tenant. But how can that be? Because I've already told you that's not a ground for eviction if in fact you agree to move and you don't move. It's not. It's not one of those 12 reasons, and you need one of those 12 reasons to evict. So I'll tell you what my agreement does. You're free to copy this or you're free to hire me, which I would suggest. In addition to having the tenant waive all of his rights for suits and hold harmless and all the full release, we don't call this exactly a cash for keys agreement. We call it a cash for keys agreement slash addendum to the rental agreement. We make it part of the rental agreement. So it now, and the tenant signs it, so that's now part of his rental agreement. Now, within the confines of our agreement, we state the following, that number one, the cost of preparing this agreement that we paid that great law firm is $2,500. By the way, that's not what the cost is, but that's what the agreement says, that the cost for preparing this document by the law firm of Dennis Block is $2,500. However, the tenant has no responsibility to pay the lawyer's fee unless he violates the terms of the contract. So that's the first thing, okay? He's got to violate the terms of the contract. In addition, it says if you violate the terms of the contract, all the relocation money has to be returned. Now, the tenant takes the money and doesn't move. Can I start an eviction based on the fact that you didn't move? And the answer is no, I can't. Remember, it's not one of those 12 reasons. But you see, I have a new addendum to my rental agreement. So you know what I'm going to do? I'm going to serve this tenant with a 3-day notice to perform or quit, giving the tenant 3 days to do two things. Number one, give me back my relocation money. And number two, I need you to pay the attorney's fees, which you agreed to pay that wonderful firm of Dennis Block and Associates if you don't vacate at the end of the period as stated in the notice. Now, so the 3 days comes and goes. He doesn't give you the money back for the relocation. He doesn't pay the attorney's fees. Well, now that's part of your rental agreement. You breached your rental agreement. So now I'm going to file an eviction based on a notice to perform or quit. So I came up with this idea probably about 15, 20 years ago. We have been successful in the rare cases, and they are rare, that the tenant takes the money and doesn't vacate. But still, now we have teeth. Now, if the tenant pays the attorney's fees and pays the relocation back within the 3-day period, we have nothing. But if the tenant doesn't, then we have grounds to literally evict this tenant based on a violation of the rental agreement. And that's why I caution people, especially under RSO or other rent controlled areas, which is the only reason why you would want to have a voluntary vacate agreement, to not just go online and get a cash for keys. You really need to have this voluntary vacate agreement / addendum to the rental agreement, because that's what's going to save you. And that, my friends, concludes everything I know about voluntary vacate agreements, cash for keys. And if we have some questions, or if you have any questions, Jeff, we can open it up now. Got to unmute yourself.
There we go. All right. Yay. And applause from the crowd. Thanks for that, Greg. All right. So we do have a couple questions. I forgot to mention, before we get to questions, I forgot to mention that we sent out a couple different campaigns to oppose different things that are on the government's desk right now. There's 628, AB 628, and AB 246. Those two things are on his desk, and you can go to the AOA website if you didn't get that email. You could go aoausa.com/PAC, PAC, Political Action Committee. So you could go there and just send the letter. It's kind of like an automated thing. You can adjust it if you want. And also, there's gonna be a meeting in Palm Springs on Saturday to try to organize members, owners that are in the Palm Springs area, because the City Council of Palm Springs is looking at getting a rent registry going. And so owners there need to organize. We got a member there that's going to lead a meeting out on that. So there's going to be an email coming. So again, just watch your email boxes, and let's take action, because we can win if we do take action. We've beaten statewide rent control 3 times, and it's when people get involved, then we can stop it. So anyway, but so thank you for letting me take a second to do that. But we have Angelo on the buyout. Can we issue a 1099 to the tenant?
Well, that's considered income, so I would say yes, you could. do that. By the way, if anybody's in the Zoom meeting, if you electronically raise your hand by
Right.
hitting that one on the bottom there, it might be in a folder called reaction if you don't see it, and we'll know to call on you and you'll be on live.
There we go. I'm gonna try to make this smaller, move my screen around so I can see this. Okay. Where did it go?
By the way, a very patriotic tie, Jeff.
Thank you. Thank you. Thank you. All of a sudden in my key where I have my questions here.
Let's
Oh,
see
here
if
it is.
in the
Okay,
chat.
found it. I pinned it. Okay, got it. Okay, does your firm work in San Diego County?
No, we don't do work in San Diego County, but we can, of course, do a voluntary vacate agreement for you, regardless of where your property is.
Right. And for San Diego County, Franco Simone is there with the Landlord Legal Center, and he operates there in San Diego. So I would encourage you to give him a call. You can look him up in the magazine or online where we have the contractors and vendors on the website. That's AOAUSA.com, and then there's a contractors and vendors tab. All right, Mario, do you have a copy of the voluntary agreement for us to use?
Well, we actually charge for that. So if you call the office, we will prepare it for you based on the criteria. But at least I've gone over the concept of why I think instead of a simple cash for keys agreement, why I think you should really have ours, which also has all the tenant release forms included.
Right. Okay, Martin, how often can I talk to tenant about cash for keys? I don't want to be accused of harassment. This is a great question. Thank you for that one, Martin.
Well, I think you can certainly ask once and see his reaction. If he's thinking about it, then I think you could have a further discussion with him. But if he says, absolutely not, I'm not moving, at that point, I would back off.
Yeah, for LA County, with the tenant harassment ordinance, what is it like once a year, twice a year? What is it?
I think it's just once a year is what,
Okay.
as remember, I'd have to look that one up. But again, I mean, it is America. You are allowed to talk. I don't think just maybe asking somebody, hey, I'm willing to give you money. I don't see that as harassment. But, these politicians try to elongate anything in the farce of tenant protection. What they need is they need landlord protection, Jeff. That's what the ordinance should.
Seriously. You're right. Heinrich here, do we use the same agreement for a non-RSO Section 8 in LA City?
Yes, you would use the same agreement because all properties now are under the just cause ordinance if they're not under the rent stabilization ordinance, and you still need cause to evict, and that is not one of the reasons to evict. So it would certainly work for all residential properties in Los Angeles.
Yeah, and hopefully you're talking about a buyout agreement and not a lease agreement. But anyway, Wilson, is smoking in the unit a sufficient violation? And how do you
If your rental agreement prohibits smoking and the tenant's smoking in the unit, then you certainly have a ground to bring forth an eviction. The problem with those cases is proving that the guy's smoking. So you're going to serve a 3-day notice, cease smoking within the 3-day period. You'd have to actually catch him after the third day. And the issue is, well, I walked by and I smelled smoke. He's going to claim, well, you know what? Maybe somebody in another area was smoking and it just the wind blew it your way. So it's kind of difficult to be able to prove those cases unless you actually see him smoking.
yeah, just with that, have you been able to prove how have your clients been able to prove it? Like, how did they? I mean,
Well, I mean, their position is that they've either seen him or that the apartment's all by itself and we smell that smoke. And we'll have, let's say, a next door neighbor who has adjoining walls, and he'll come in and say, yes, the guy's smoking because it's coming through the wall. So we have been
okay.
successful in those, but I always caution that it is an issue dealing with proof.
Yeah, not your best grounds for eviction, probably though, huh?
Not the best.
Yeah, okay, Wendy. For RSO and unincorporated LA County, do we include the voluntary vacate agreement addendum at the time a new tenant is moving in, or can it be added to an existing tenant lease?
No, you certainly wouldn't want to do that when the tenant's moving in. You only want to do that once you've talked to the tenant and the terms have been established orally, and then you then prepare the agreement. But again, by preparing the agreement, it's not just quote cash for keys. It's a voluntary vacate agreement slash addendum to the contract. And by making it an addendum to the contract, now if you don't comply, I have a basis to evict you based on failure to repay the relocation if you didn't move, and also to pay the attorney's fees for preparing the document.
All right, Keith, does LAHD need to be notified of the voluntary agreement?
Good question. The that disclosure form that's signed by the tenant, which I shared my screen on, has to be filed with the city. You have to send it into the Los Angeles Housing Department with a copy of the voluntary vacate agreement.
All right, on YouTube, B Dude. In the case you presented, cash for keys amendment to the rental agreement. After a tenant is forced out, can we file in small claims to collect the incentive money?
Oh, absolutely. Right, because the unlawful detainer is not going to get your uh, well, you could probably, he did move, okay? So I don't think, we don't have it worded where if you don't move, you don't get the relocation because that would create other problems. So I think he's entitled to the relocation even if you had to evict him, but certainly he would be responsible for the attorney's fees for preparing the document as stated in the contract. And also, if you are suing him for eviction, you'd also be able to get your attorney's fees back on that, depending on what the rental agreement states.
All right, Angelo, what about marijuana smoking ordered by a doctor?
Well, that's a tough call. If the tenant claims he has a disability, and by the way, this is just hogwash, and the doctor should lose his license immediately. But if he does, then under the Disabilities Act, he has the right, you have to allow for a reasonable accommodation if a tenant has the necessity, oh my God, the necessity to smoke marijuana. However, that doesn't mean he has to smoke it in the unit, and that doesn't mean that the rights of other tenants have to be tortured because of your disability. So you can come to a meeting of the minds where maybe he has to smoke not in his unit, but outside of the unit, maybe in the back of the unit by the garbage cans. Maybe you require him to smoke it inside the garbage cans, but at least so he's not bothering other tenants. But you are gonna have to allow him based on that, this quote, reasonable accommodation.
Right, and I believe there's more than one way to consume marijuana.
That
Doesn't
is
have to be
true
smoke.
too. Yes, but I'm sure the doctor's going to say no, it has to be inhaled only.
Okay,
Doctors will say whatever you want them to say. I had a
okay.
doctor write an emotional secure pet letter that the tenant needed to have a rooster. Insane. That's what the doctor
Oh my
said.
goodness. Okay, Afshin here. Do you see any difference in the city of Santa Ana in comparison with the city of LA? Great question.
Well, Santa Ana has its own rent control too. So, and in their reasons for eviction, it's not one that he signed an agreement you didn't move. That is proper cause for eviction under statewide rent control, but not in Santa Ana, which has their own rent control. So again, this agreement would work well there if you can incentivize a tenant to move. I mean, that's really all we're talking about here. And again, if the rent is close to market value, it's on deaf ears here. But if you get $1,000 or more for a unit, that's worth a lot of money to you.
All right, in the Zoom meeting here, we have Lewis. Is there any particular verbiage that should be included in a new lease in anticipation of a possible buyout in the future? You did answer that and said no. Am I
No,
correct?
I don't think there's any reason. First of all, if it's a new lease, guess what? You're going to be at market value. So you don't need to even consider giving them a voluntary vacate agreement. Make sure when you rent out your units there that they're at market value. And if you're curious as to what market value is, I've said this on many telecasts, go to a website. It's free for the first 5 times. It's called rentometer.com. So that's RENT, the letter O, meter, METER.com. You put in the address of your property, you put in what kind of a property it is, an apartment or condo or a house, and you put in how many bedrooms, and it'll spit out a list in seconds of 20, 30 apartments that rented similar to yours within, let's say, a quarter-mile radius of your property, and it'll tell you what everybody else got. You got to make sure that you're at market value.
All right, Van, I see you got your hand up there.
Yeah, I had a question. This is my first time. I've seen your stuff in the magazines, but Dennis, honored to talk to you. Say, listen, my question concerns from the tenant standpoint, if they are being sort of evicted, but under one of these deals, do you think that would qualify as an involuntary conversion from the tenant, or do you know any thoughts on that?
I have no idea what you mean by the term involuntary conversion. Explain.
Oh, okay. It's under 1033. You know what a 1031 is. It's an
You're talking
exchange.
about a tax exchange?
Yes, it's a different provision of the Internal Revenue Code. It's a 1033. In other words, if your house is or your property is taken from you, you have 2 years to replace it under as involuntarily.
I'm not sure how that relates to a landlord-tenant issue, but I would
Okay,
probably suggest that you talk to your CPA, but I don't think it's a landlord-tenant issue at all.
okay. I am the CPA. That's why I don't know everything. You sound so knowledgeable. Okay.
Knowledgeable in one area, actually two.
Oh,
I
I know.
can tell you fact by fact everything about the Lakers, including that my season's starting pretty soon. And by the way,
Mhm.
Jeff, you should know we're taking a trek to this year to Boston. I'm going to be in the Boston Gardens, and then we're also going to hit on a different trip New York. So I'm going to be chasing the Lakers around this year. But uh,
Awesome.
but honestly, I'm not the best person to ask for 1031 or 1033s. But anyway, thank you very much.
Oh,
And we have another one there,
Yeah,
Jeff.
I don't see another one in the Zoom, but we do have a couple more here in the on YouTube. And it's AJ, if there's a strong smell, odor in the unit like urine, is that evidence that it must be cleaned by renter when they move out?
Yes, of course. I mean, you have to return the premises to a neat and sanitary condition. So that would certainly be a cost to deodorize the apartment, and that certainly could be deducted from the security deposit if that's the issue.
Do you need to wait for them to move out?
Well, if there's a problem and it's bothering other tenants, yes.
Yeah, you
And
don't
then
have to wait.
I would demand that the tenant
Yeah.
do it. If the tenant didn't do it, I would do it myself, and then I would make a demand on the tenant to reimburse me for the cost.
Well, they'll say the dog did it.
Well, but it's their dog,
I'm just kidding. I'm messing. Okay, Raquel, as my building is under JCO, but not RSO, so this person's in LA count in LA, do I have to give an interest on security deposit?
And the answer is no. It's only for RSO properties.
Okay, and we covered security deposit. Go back on the YouTube AOA USA, search that on YouTube, and or just even go from our website. There's an icon and you click on it, boom, it takes you right there. And don't forget about Dennis Block's show that he does on Saturday mornings
Well, actually, Saturday afternoon
or
at
more. Yeah, that's right. Yeah,
3 p.m., you can either jump on, if you go to my website, evict123.com, you can jump on either the Zoom meeting where you'll be able to ask questions like in this forum, or you can do YouTube Live, but the show is always on YouTube, so you can see the past shows. And this week I'm talking about the law that's already in effect dealing with zoning changes, where you're now going to be able to build an apartment house on in a neighborhood with single family homes. You're going to love this show.
cool. And also we are gonna, like I don't know if we got the email campaign out yet or not, but there's also LA County is looking at an eviction moratorium. Have you heard about that, Dennis?
Eviction moratorium for
LA
what?
County.
But I mean, they do have one that if you claim you're a victim of the fire, then your rent is deferred, and they might be increasing that.
Yeah, this one is for ICE if you're impacted, if you have a
Uh,
financial hardship due to ICE raids. And so anyway, we sent out a campaign against that. We're just anti-moratorium more than anything else.
yep.
So yeah, you'll see that. Check your email, check your spam. If you're not getting them, give us a give us a bell or email us at membership@aoausa.com. Really, on the website, you should be able to subscribe to these different things. If it's especially political action stuff, go to the political action part of the website. That's aoausa.com/pack. Okay, is this another? Yeah, no, that's it. I think we're good on the. Oh, wait, let's see. Do we have one more? Okay, last question here, it looks like. Christine, can we ask the tenant to clean the unit and return it in the moving condition in the buyout agreement?
You can ask for anything in a buyout agreement. It's whatever the parties agree to at the time. But then again, you're probably going to be doing some renovation. The big motivation is to get the tenant to move so I can raise the rent. So you don't want to put any impediments in front of that tenant. You want to make it easy because you're going to stand to make a ton of money on the value of your property and also on your income.
Okay, here's one. This is kind of hotly debated, and I think there might be a couple different opinions on it. With the rent freeze for these areas that have been impacted by the fires, there are attorneys out there saying that you can't raise the rent after someone moves out, you can't raise the rent by more than 10%. There's others that are saying you have this 160%, which you've probably heard of. Others that are saying just raise it straight to market. What's your opinion on that,
Well,
Dennis?
my opinion has always been that under the Costa-Hawkins Rental Housing Act, that statute says specifically, notwithstanding any other law, you have the right to raise the rent to market value. I'd have to really take a look and see the statute dealing with just LA County and the fires. But I mean, this is just such a usurpation of property rights. But again, I
Right.
still think you have the right to do it.
Because really, at any point in California, there's an emergency order in place which would say, oh, if the anti-gouging code would say, yeah, you can't raise anything above 10%. And so some attorneys are taking that one and saying, no, you need to, if you really want to go by the letter of the law, that's what you need to do. I think the biggest thing is just don't list it for market and then bump it up 10%, right?
Right,
That's where you're going to get in trouble. But if
exactly.
you want to play it really, really conservative, then you would just, I guess they'd do the 10%.
Yep.
Okay.
And you're safe with 10%.
Right. But Costa Hawkins is a great defense, but hopefully you don't have to use
You
that
don't want to have
defense.
to fight your battle in court on that one.
Yeah, right. Well, hey, I really, really appreciate you, Dennis, and looking forward to the next legal Q&A. And you guys should be getting your magazines here in another 10 days or so. And so check it out, what he's got to say. Anyone else, if before we close this thing down? Okay, we're good.
Good job.
And yeah, thanks, man. Thank you so much. And we have another meeting at 12 o'clock today. If you want to learn about the 1031 exchanges and into Delaware statutory trusts. And anyway, so join us for that if you're around. Take care.
Bye-bye.
Bye.